Welcome to Whatsoever More or Less. My name is Jason. I have a thought today regarding Ezra Taft Benson and what he said in his talk defending the Constitution, a Heavenly Banner, which was a talk given while he was prophet of the church at the bicentennial of the Constitution, and a larger book version plus a shorter general conference version. So one of them was a BYU talk directed to all members of the church around the world. Anyhow, what he said was, we have chipped away at every major clause of the Constitution. We have not been wise stewards of that with which we have been entrusted. Okay, so that's a really important starting point for this conversation that I want to have. And I've recently read a John Taylor quote where he had said something similar had already begun to happen back in his day. You know, John Taylor, that was back in the 1800s. Anyhow, let's start off then with this idea that if a prophet of the church has said, yes, he verified the Constitution hanging by a thread prophecy, not the white horse prophecy, but the Constitution hanging by a thread prophecy, but even more importantly, he said he declared unambiguously a prophetic statement of, we have chipped away at every major clause of the Constitution. So now then the question becomes, how has that happened? If you are looking at the Constitution and all you want to see is rah rah America, you're not going to see it. If you are looking at the Constitution and all you want to see is I hate America, America is guilty and they got to be condemned for it, you're not going to understand things either, because hanging by a thread means, to me, I think I've recently been given the comparison of internet exists nowadays. You want to put up all these safety barriers and protections for kids at the house. So you've got maybe this check, maybe that check, maybe that check, maybe that check. The kid has to get through this, has to get through that, has to get through that before they get access to certain things. That's all there is to it, right? And so if it's hanging by a thread, that something is still hanging on that's preventing the worst possible outcome from happening, okay? And so no, I don't think that the worst possible outcome is there, but if you also believe that we are like 100% true to the Constitution and that our modern education system is actually teaching the Constitution, no, I don't buy it for a second. Our modern education system teaches what could be called stare decisis or settled law. There's no such thing as stare decisis allowed for in the Constitution. There's no such thing as the concept of settled law allowed for in the Constitution. In other words, you can't say, well, I forced you to because I brought the military in and I forced you to do what you thought, you weren't constitutionally obligated to do, but I told you have to do it, and my view is true because I forced you by way of the military. No. If you say, well, we had the Supreme Court come up with some fancy explanation for why it works, if that fancy explanation doesn't comport with the text of the Constitution, no, it doesn't matter how good sounding it is. If the president has an explanation for why something should be this way and that way, but it doesn't comport with the text of the Constitution, but he wins, a battle by bringing the military and enforcing it to happen anyhow, no, you can call it settled law, but those are not legitimate constitutional processes for actually creating law that's going to be settling to anyone who actually studies the Constitution. It's unsettling law is what it is. Once you study the Constitution, like, this does not work out. There is no process. The processes, for example, are found in Article 1, Section 7, Clause 2. They're found in Article 2, Section 2. They're found, they're referenced kind of in Article 3, Section 2. But rather, really, the concept is law and equity, right? This is not a process for amending the Constitution or anything like that. There's a process, there's a backup process is what I'm going to call it in Article 4, Section 4. There's a process in Article 4, Section 3, Clause 1. There's a process in Article 5, a very huge process, a very important process. There's a process in Article 7. There's an implied process in Article 6, Clause 3, if you ask me. But no, there is no way you can settle law by making up explanations that sound good, that don't comport with the text of the Constitution. Even if you're willing to enforce them by way of a military that wins the battle, it doesn't change the fact that it doesn't comport with the text of the Constitution. So now moving on here. So let's see what is the actual Constitution. The Constitution is the written word The only legitimate interpretation of the Constitution is the original public meaning, as James Madison said in his older years, or perhaps better said yet, governments derive their just powers from the consent of the governed. And so anything that was discussed in back rooms, in framing conventions, things like that, that wasn't written down and presented for ratification is not a just power, because there's no way the governed could give their consent to it by way of the Article 7 process or by way of the Article 5 process. All they can give their consent to is that which is presented to them in writing, and so any other supposed powers are not just powers. There are implied powers without a doubt. The implied power is not Article 1, Section 8, Clause 18, if you ask me. Article 1, Section 8, Clause 18 is simply saying if something is necessary and proper to be done to carry out one of the powers granted in this Constitution, then we're allowed to do it, right? It has to actually be necessary and proper, okay? However, Article 6, Clause 3 is where I find the most important implied power. Article 6, Clause 3 tells me that someone has taken an oath of office to the Constitution, that it's impossible for them to keep that oath of office to the Constitution if they know the Constitution and are given unconstitutional laws to enforce, and then actually choose to enforce those laws. An intelligent person would know the difference between what the Constitution says and what they're being told to do, and they would say, I cannot execute this law. It would be a violation of my oath, and we call that nullification. So the implied power is nullification. The implicit power of anyone who's taken an oath of office to the Constitution. So let's go ahead and look and see who takes an oath of office to the Constitution. As I understand it, all state officers, officials, whatever you want to call them, and all federal officials. Can I track down every last person that's taken that oath? I don't know all the details. I'm working with original public meaning here, so I would imagine it's most people that have taken that oath, okay? If they work for the government. So, but anyhow, coming back to then, if the Constitution, what is the law? What is the law of the land that everybody swears to uphold? It's the Constitution, the laws, and the treaties. Then the state laws are below them, but the state laws are valid where they exercise a power that is legitimately reserved to the states or the people respectively, right? So Article 6, Clause 2, we call it the Supremacy Clause. Supreme Court rulings are not the supreme law of the land. Ideas that were enforced by way of military force and imposed on people but never actually ratified into the Constitution are not part of the supreme law of the land, and never will be until they follow the proper Article 5 process. There is nothing settling about the idea of treating something like it's the law of the land when it has never once been put into writing, and the governed have been given the option of consenting to it or not consenting to it. So it is an unjust power at that point. It is not part of the supreme law of the land. Again, the supreme law of the land, Article 6, Clause 2, is the Constitution, then the laws, then the treaties. Now, who has the power to enforce then any one of those three things? Period. With or without, okay, so there's two different kinds of cases we need to know about: cases in law and cases in equity. Really, all a case in law means is where additional legislation has been given that prescribes a punishment, and prescribes thresholds of this caliber of crime versus that caliber of crime. This is just me kind of quickly describing it. Anybody feel free to correct me in the comments. And then when this threshold of crime is met, this threshold of punishment or this parameters are allowed for the punishment. That's a case in law, versus a case in equity is basically where something is a constitutionally protected right, constitutional promise, and yet there is no specific legislation yet backing up the prescribed punishments, etc., the prescribed remedies for violations of those rights. The Constitution allows for both to be protected, okay? Cases in law and cases in equity. So I guess I'm going to go ahead and start off referring to Article 3, Section 2, Clause 1, the opening phrase. If the Constitution makes a promise, there has to be some level of judicial branch. which it may be the Supreme Court, but based on the exceptions clause, it may be reserved to a lower court after the Congress has established that lower court. But a case in equity may happen, where basically the Constitution promises this is a right, etc. It has been violated up front. We don't need the 14th Amendment. Article 3, Section 2, Clause 1 says the judicial power of the United States shall extend to all cases in law and equity arising under this constitutional laws and the treaties. And this is me paraphrasing again, as always, because I always make these videos while I'm doing something else. Thank you for listening to them if you are somebody who listens to them. Who else has the authority to enforce the Constitution with or without additional legislation being written around it? In other words, if there is a constitutional promise guaranteed, such as Article 4, Section 2, Clause 1, or such as the Fifth Amendment, okay? Now let's talk about the Fifth Amendment real quick here. Apparently, Madison originally intended for the Fifth Amendment to be included in Article 1, Section 9. But guess what, guys? It doesn't matter. That's not what was presented to the governed for their consent. What was presented to the governed for their consent was the Fifth Amendment as a standalone amendment. So the only valid enforceable meaning of the Constitution is the original public meaning under which it was ratified. In other words, the definitions that would have been understood in the dictionaries of the time applied to the text as plainly understood by your average reader, such as Joseph Smith, 30, 40 years later, whatever, after this was ratified or that was ratified. Joseph Smith would have known the original public meaning. It wouldn't have been hard for him to ascertain. So, anyhow, so clearly the Fifth Amendment does not specify which level of government it applies to. Therefore, it has to apply to all levels of government. And, say, for example, Barron v. Baltimore, the case was brought by a former U.S. Attorney General, the longest-serving U.S. Attorney General that we've ever had, William Wirt. This is no legal slacker. And the case was still shut down by John Marshall because he was looking at original intent. Saying that's like backroom power, that's a secret combination. Nobody else knows it. It was not presented to the governed for their consent. Therefore, it cannot be the valid meaning. It's not a just power. It's a stolen power. It's a usurped power. It is not a true just power. Okay, so anyhow, so the president has a take care clause in Article 2, Section 3. He says, basically, he shall take care that the laws are faithfully executed. Well, once again, Article 6, Clause 2 tells us the order of the priority of the laws, the Constitution, the laws, and the treaties. And so they're all considered the supreme law. And then the states afterwards, when exercising laws that exercise powers that are reserved to the states or the people respectively. This is not an optional thing. I think you have to remember one of the most common sense things I found when analyzing the Constitution is what I call my 7 Ps, which gives the proper purposes of government existence, right? Then the Constitution straight up covers that, okay? Then the positions of power, then the manner by which the people's consent is given to each of those positions of power, then the procedures by which the exercise of those powers is made official, then the powers enumerated, the powers prohibited, and the promises guaranteed. I think we don't spend enough time talking about the promises guaranteed. We're so obsessed with enumerated powers sometimes that we fail to acknowledge that really wherever there's a promise guaranteed, it is spread across all branches and levels of government. And I'm going to make my case right now. So say, for example, protection from organized violence, let's go ahead and say a massive mob in a state, or a military invasion, or the threat of a military attack on our shores, what have you. Who has taken an oath of common defense? Who has taken an oath of domestic tranquility, ensuring not, maybe kind of trying to make it possible that domestic tranquility happens? Who has taken an oath to that? Everybody. Article 1, Section 8, Clause 15, and also even 14, I think is relevant. But 15 straight up, whether or not there's other legislation passed or not, if the Constitution promises something, the Congress can call forth the militia to go deal with it, to go deal with stopping a violation of constitutional promises guaranteed, and then afterwards, if it needs to be brought before the courts, you've got yourself a case in equity if there's no legislation surrounding it. So basically, Article 3, Section 2, Clause 1 allows for the courts to deal with cases in equity. In other words, where no other legislation is passed yet, but a constitutional promise is there, period, the courts already have authority over it. And then again, the take care clause. And then Article 4, well, so let's look at Article 3, Article 1, Section 10, Clause 3. And that is where the states are authorized even to take military actions to prevent against invasion, other stuff like that, until the federal government gets it under control. If the federal government abdicates their duty, nothing obligates the states to put up with that and to cease. If the federal government does not get it under control, the states have an ongoing authority. That's all there is to it, an ongoing obligation to that constitutional promise. Article 4, Section 4 requires that if the states cannot get their violations, this domestic violence type of thing going on, what have you, they cannot get that under control. I would say the governors and the legislatures of the states it's not an optional power for them. It is a promise guaranteed. They are obligated then to apply to the federal government. Where they are incapable of applying to the federal government or unmotivated to do such, it doesn't matter. Again, Congress has sworn an oath and they have the power. Article 1, Section 8, Clause 15. President has sworn an oath and he has the power of the take care clause. This is an obligation. It is not a power. It is an obligation, which is even more important than a power. And so anyhow, I think what I'm getting at is Joseph Smith said, anyone who's sworn an oath to the Constitution who fails to defend those rights guaranteed by the Constitution, those promises guaranteed by the Constitution, should be potentially guilty of, have the potential of being punished by death, right? The death penalty for violating such an oath of office. It was that huge a deal to him. So, and again, which we have the breakup of the powers between the legislative, the executive, the judicial, the states, the officers of government, and even we the people have not sworn an oath to it. We've given our consent to it. We cannot give our consent to anything other than that which is presented to us in writing. So if you do not present it to us in writing, but you say, well, we always meant for it to be this way, I don't care how cool your explanation is. It is not part of the Constitution. It is not a just power. It is usurpation. So again, President Benson said, we have not been wise stewards of our Constitution. We have chipped away at every major clause, and he confirmed the Constitution will be hanging by a thread. There's so many confirmations of that, it's not even funny. Hanging by a thread means there's still that last little bit of something that's keeping everything from completely falling apart and falling into a completely non-constitutional republic, and obviously tyranny of arbitrary power. Something is still keeping that from happening. Clearly in the United States, that is obvious to me. However, it is also obvious to me too that we really have chipped away at every major clause of the Constitution. Anyone who wants to I think even the Reconstruction Amendments, they're absolutely unnecessary. Absolutely unnecessary. They don't stand up to scrutiny. The way they were passed does not stand up to constitutional scrutiny. There are not just powers. The Civil War was not a just power. It does not. I don't care how cool Abraham Lincoln's explanation was of the Constitution really must mean this or it must mean that. If it's not plain in the text, if it doesn't comport with the original public meaning, what would have been understood, what would have been given the consent to the governed, it is not a just power, and therefore, according to your Article 2, Section 3 duties, you need to bring it before Congress and recommend to them that they consider proposing amendments to the Constitution and trying to get 3/4 of the states to ratify. If they can't do it, they have to understand that it is not a just power for them to do it anyhow. That is all there is to it. You can say, okay, the president exercising powers of war without constitutional declarations of war, That's not the consent of the governed. I disagree. He has the obligations. We have to remember, it's not just powers prohibited, powers granted, powers enumerated. It's also promises guaranteed. You have to consider the promises guaranteed. And the Constitution is the supreme law of the land. The president has to take care that the laws are executed. The Constitution promises protection from invasion, domestic violence, common defense, etc. These are not optional duties of a president. He does not have conditional powers such as Article 1, Section 10, Clause 3 like the states do. His is a plenary power. I would say Article 1, Section 8, Clause 11, therefore, falls under the category of the backup plan, especially where a state of war already exists, as Alexander Hamilton would have said in Examination Number 1. Not that I am reliant on Alexander Hamilton to understand the meaning of the Constitution, but even he could see that. So, Jefferson, he gave the Kentucky resolutions. Madison gave the Virginia resolutions. The Kentucky resolutions comport more with the plain text of the Constitution. The Virginia resolutions don't. But the Virginia resolutions were given by someone who had participated at Philadelphia and knew the backroom conversations, versus the Kentucky resolutions were given by someone who just knew the pure plain text of the Constitution, what it would have meant to somebody at that time. And so I would say Jefferson's meaning is the most inspired. I've looked in, by the way, in the indexes of, say, for example, Ezra Taft Benson's books. Guess who's referenced most? Jefferson regarding the Founding Fathers. By far. He is so quoted, it's not even funny. So, do I think Jefferson got it completely right? I think that Alexander Hamilton was right to call him out when it came to the Barbary Pirates incidents. I think he had too much caution in some places where a promise was guaranteed. Personally, that's my stance for now, and I reserve the right to modify it. I've clearly modified my view of Article 3, Section 2, Clause 1. I still stand by that they have been granted no permission to redefine the Constitution for the rest of us, no matter how cool their explanation is in a case. To make the judges oath-bound to the previous explanation of previous judges, you're just inviting for the Dunning-Kruger effect, which is basically perpetuating incompetent decisions. Every judge should be reading the Constitution for themselves, and it's paying very little attention, only basic attention to the decisions of previous judges, just enough to consider the possibilities, but never to let it override the Constitution itself. So anyhow, that's my thoughts. Thanks for listening. Again, we've chipped away at every major clause. The Constitution is hanging by a thread, or will hang by a thread, but that thread is still keeping us from completely falling into arbitrary power for now. While there is a lot of being in all arbitrary power, we're just not completely there. That's the way I would interpret it. Joseph Smith looked at all this stuff. He went to President Van Buren. To him, it was the most obvious thing in the world reading the Constitution. It wasn't a suggestion. It was a promise guaranteed. It wasn't a power. Stop thinking about powers granted and powers prohibited only. Think about promises guaranteed and oaths. And again, Joseph Smith said anyone, any level of government having sworn an oath to the Constitution, doesn't uphold and defend those promises of certain rights and what have you, protections, should be subject to the death penalty. So that's a really strong, profound statement. This is me just paraphrasing. Thanks for listening to me. We'll talk to you later.